How to make a will in Washington State 2025. What happens if you pass away without a will in Washington? Does everything automatically go to your spouse or kids? Or does the state decide who gets what, leaving your family stuck in court, paying fees, and possibly fighting over your property? Here's the truth. If you don't have a valid will, Washington's intestacy laws take control. That means the government decides how your assets are divided, not you. It's a recipe for conflict, delays, and heartbreak. But the good news is this: creating a valid will in Washington is straightforward, and with the right guidance, you can make sure your wishes are honored and your loved ones are protected. So today, I'm walking you through exactly how to make a will in Washington State in 2025, step by step, so you can safeguard your legacy and give your family peace of mind. Hi, I'm Jason Gray, an estate planning attorney here in Washington. Every year I meet families who assumed they didn't need a will or thought their assets would just naturally pass to the right people. And I always think the same thing: this could have been avoided. So in this video, I'll show you how wills work in Washington, the exact requirements to make one valid, the mistakes that cause wills to fail, and the strategies that can make the process smooth and effective. Let's get into it. What is a will and why does it matter? A will is your personal instruction manual for what happens to your estate when you pass away. It says who inherits your property, who will serve as the guardian of your minor children, and who you trust to act as the executor, the person who carries out your wishes. Without a will, Washington law steps in with a default plan called intestacy. That plan doesn't know your family dynamics, your relationships, or your priorities. It simply follows a formula: spouse first, then children, then parents, then siblings, and so on down the line. That might work for some families, but for many, it creates chaos. Having a will means you, not the state, get the final say. The steps to create a valid will in Washington 2025. Step 1, meet the requirements. You must be at least 18 years old and of sound mind. That means you understand what you own and what it means to distribute it. Step 2, put it in writing. Verbal promises don't count. Washington requires wills to be in writing. Handwritten wills are not recognized unless they meet all the formal witness requirements. Step 3, sign the will. You must sign the document yourself, usually at the end. This is your confirmation that these are your true wishes. Step 4, have 2 witnesses. This step is critical. Washington law requires 2 competent adult witnesses to be present and watch you sign. They must also sign the will. To avoid conflicts, your witnesses should not be people who stand to inherit from your estate. Step 5, name your key people. This is where you name your executor, also called a personal representative. This person handles your estate, pays your debts, and distributes your property. If you have minor children, this is also where you name a guardian. Without this, the court decides who raises your children. Step 6, store it safely. Once signed and witnessed, your will should be kept safe. You can place it in a fireproof safe, leave it with your attorney, or file it with the clerk of the court in your county for safekeeping. Done correctly, these steps create a legally binding will in Washington that ensures your wishes are respected. Now let's cover some common pitfalls. Washington does not currently recognize electronic wills unless they follow strict formalities. Simply typing something up and signing it digitally won't be enough. Another big mistake is failing to update your will. Life changes, marriage, divorce, a new child, even purchasing new property. If you don't update your will after major life events, your estate plan can become outdated and leave your loved ones in a legal mess. And here's something else. If you own property outside of Washington, one Washington will may not be enough. You may need additional estate planning tools like a trust to make sure everything transfers smoothly. Finally, don't assume that a will covers everything. It does not override beneficiary designations on things like life insurance or retirement accounts. If those aren't updated, they can go to the wrong person regardless of what your will says. Once your will is in place, don't just file it away and forget it. Review it every 3 to 5 years or any time a major life change occurs. Pair your will with other critical documents like a durable power of attorney and an advanced healthcare directive. These protect you while you're still alive, ensuring someone you trust can handle financial and medical decisions if you're unable to. Think of your will as one piece of your overall estate plan, important but not the only document you'll need. Protect your family with a proper will. You've worked hard for your home, your savings, your legacy. Don't leave it to chance. Making a will in Washington isn't about you. It's about protecting your family, avoiding unnecessary court battles, and making sure your wishes are carried out exactly as you intend. If you're ready to create or update your will the right way, click the link below to schedule a consultation with us. We'll guide you through the entire process, make sure everything is legally valid, and give you the peace of mind that you deserve. And if you found this video helpful, check out my next one. YouTube thinks you'll love it.